Today is the 13th day of September 2010. The program is United Nations Week News and Views. Welcome again. My name is John Kerry, and the views expressed are mine alone unless I indicate some other source. The first subject I want to take up today is defamation of religions. That's a slogan that has been very much pushed at the UN, particularly from non-Western countries. The idea of it is to get agreement sufficient to found a principle of customary international law, agreement on the proposition that if you defame somebody's religion, you must be punished as a criminal. We, the United States, have resisted that proposition, and it's a very welcome sight and news to note that in the latest report by the Special Rapporteur on Defamation of Religions, a very different tack is taken. The individual in question is Githu Muigai of Kenya. And according to the website of his law firm, which is called Mohammed Muigai Advocates, quote, Githu Muigai holds LLB and PhD degrees from the University of Nairobi and an LLM degree from Columbia University School of Law. He's also a fellow of the Chartered Institute of Arbitrators in the UK and a member of the American Association of Trial Lawyers. He was called to the bar in 1985, and in addition to practicing law, he's an associate professor of public law in the School of Law of the University of Nairobi. He specializes in public law and transnational legal practice and is a recognized authority on business regulatory matters and in international commercial arbitration, so says the website of his firm. Well, his latest report goes like this at paragraph 90, quote, with regard to stereotyping of religions, he, the Special Rapporteur, recalls that vigorously interrogating and criticizing religious doctrines and their teachings is thoroughly legitimate and constitutes a significant part of the exercise of the right to freedom of opinion or expression. That is very different from what we have been hearing from many non-Western countries on this subject. Continuing the quote, therefore, the Special Rapporteur would like to reiterate that domestic blasphemy laws aiming to protect religions per se can prove counterproductive, since they could result in de facto censure of robust examination of religious doctrines and teachings. Imagine that, robust examination of religious doctrines and teachings, and of inter and intra-religious criticism. Imagine inter-religious criticism. Continuing the quote, consequently, the Special Rapporteur encourages states to move away from the notion of defamation of religions towards the legal concept of advocacy of racial or religious hatred that constitutes incitement to discrimination, hostility, or violence, in order to anchor the debate in the relevant existing international legal framework, in particular that provided by the International Covenant on Civil and Political Rights, unquote. In other words, let's not go trying to make some new rules of law dealing with this subject. Let's just apply the law that exists, which is quite adequate in his opinion and also in mine. His report covers the following subjects: acts of violence or discrimination or incitement thereto against individuals on the basis of their religion or belief, attacks on religious sites, religious and ethnic profiling, religious symbols, and finally negative stereotyping of religions, their followers, and sacred persons. The United States comes in for some criticism in paragraph 40 of his latest report, and I quote some of it. According to the 2009 Global Sikh Civil Rights Report, there have been a number of cases where Sikhs have been incorrectly detained and face harassment when entering the United States of America. reportedly a repeatedly occurring process for some Sikh individuals, including those who have no criminal records and are citizens of the USA, was described as follows. Upon disembarking the plane, the targeted individual is identified and escorted by 2 officers of the Department of Homeland Security. The officers take the individual through immigration and then onward to baggage claim. After the baggage is picked up, the individual is taken to a private location where the baggage and person are searched. All documentation with the individual is photocopied and the individual's phone is taken and information on the phone stored by the officers. The individual is questioned in detail about the trip and the individual is released. Throughout the entire experience, officers allegedly treat the individual rudely, asking pointed questions in a manner that is threatening, as if the person is a suspect, and the experience lasts approximately 2 hours. Now, listen to this point made by the Special Rapporteur. He acknowledges that states are obliged to take effective measures in preventing and combating terrorist attacks, and that profiling is, in principle, a permissible means of law enforcement activity. But he would like to underline that this practice raises human rights concerns, in particular regarding the principle of non-discrimination, the right to privacy, the right to freedom of movement, and the right to personal liberty, which are all enshrined in the International Covenant on Civil and Political Rights. Now, the next few paragraphs deal with limitations on religious manifestations in a variety of countries: Turkey, Italy, Switzerland, India, Quebec, Canada, Germany, Bangladesh, Belgium, and Spain. Now I want to mention how Mohammed El-Baradei, the recently retired head of the International Atomic Energy Agency, having returned to his native Egypt, is confronting President Mubarak. The Guardian's online news of September 9th related how he is urging his fellow Egyptians to boycott next month's parliamentary elections. The Guardian reports that El-Baradei, quote, has insisted that he will not stand in next year's presidential elections unless reforms take place to ensure that the vote is free and fair. In passing, I mentioned that Mohammed El-Baradei in the late 60s was a student of mine in a course that I was teaching at New York University School of Law as an adjunct assistant professor. Now I want to talk a bit about, or quote the Secretary General about the achievements of the Montreal Protocol in preserving the ozone layer. Just a few sentences here. Quote, in general, successful environmental agreements require a broad framework, clear targets, and a gradual approach to implementation. Then, as governments gain confidence, they build on initial steps and set more ambitious goals. The Montreal Protocol on substances that deplete the ozone layer, which last year achieved universal ratification, is an excellent example of this process. Well, I want to stop at that point and make an observation. I've been saying for the last couple of weeks that as regards the Middle East peace talks, I think it's a mistake for the two leaders to try to deal with the 5 major issues in the Middle East all at once and get through in a year. What I've been urging is that they start small, in line with what the Secretary General has just said. Start small with a manageable issue and make sure that their negotiations bear some fruit. And the specific example I have used is that of underground water, which exists in aquifers that cross the borders between Israeli-occupied land and Palestine-occupied land. Secretary General says, successful environmental agreements require a broad framework, clear targets, and a gradual approach to implementation. I urge a gradual approach in the Middle East peace talks, using a minor issue but one that is very important, and see if the two parties cannot get along on that level before going on to the really big problems. Well, finally, I want to report about an American being elected to the International Court of Justice. The way this works is that there are simultaneous votes in the General Assembly and the Security Council. There was only one nominee because the seat to be filled is the unexpired term of Justice Thomas Bergenthal, who recently resigned. You may recall a few months ago on this program I talked about Thomas Bergenthal and his early career, which followed his release from a Nazi concentration camp. He went on to become a leading American scholar in international law. Now, the person who is filling his seat and can serve until February 2015 is Joan Donahue. She's currently Principal Deputy Legal Advisor in the U.S. Department of State. Her duties include advising Secretary Clinton and President Barack Obama on all aspects of international law, and advising on the drafting, negotiation, and implementation of resolutions of the Security Council, General Assembly, and other UN bodies. We wish Judge Donahue well, and it certainly sounds as though she has good qualifications. Well, friends, that's all for this September 13th issue of United Nations Week News and Views. We'll be back with the next issue. Meantime, do send along your own thoughts on these or other UN-related issues to www.unweek.blogspot.com. Goodbye for now, and thanks very much for watching.